Alcock went fantastic, but at that presentation I talked quite a bit about Loper Bright and the death of something called Chevron deference. And really, when you think about the death of Chevron deference, what you should be thinking about is the death of certainty in the law. Because unfortunately, y'all listening to me keep voting for people into Congress who aren't attorneys, and as a result, our laws are terrible because we're having our laws written by bartenders and chefs and whoever the hell else you guys are electing to Congress. Look, I love y'all, but stop. Just knock it off. So we have really bad laws. And that's been okay-ish because we've had agencies that are full of, generally speaking, pretty smart lawyers that went to Harvard and Yale and actually are trying to get to the right answer. And so Congress passes a bad, vague, stupid law, and then the agencies have been able to what they call gap fill and interpret that law and provide guidance to the courts and to America in terms of what that law, which is badly worded, actually means in practice. And so at least when we have these agencies, what some folks would call these nameless bureaucrats writing our laws for us, at least we know what the laws are now. So some might say it's not a good thing. I thought Chevron deference was a great thing because it provided uniformity all across the country. Now that Chevron deference is dead, and that's what the Supreme Court held in a case called Loper Bright, what that means is these agency determinations in terms of what the meaning of a law is are no longer binding. That means every single judge out there is allowed to make his or her own determination as to what the law is. And that's bad. That's really bad. Why? Because you want to know what the law is before you get to court, don't you? You want to know if you're complying with the law before you do something that might be illegal. And you certainly don't want to find out that you broke the law only after a judge swings his gavel and says, I think you broke the law because I'm interpreting the law in a way that makes what you thought was legal illegal. And this is really important to the FCC and to the TCPA world because, of course, as we all know, the TCPA is a terribly worded statute, horrible, so vague, so difficult to apply. And the FCC has spent literally since 2003? 1992 was the first FCC order, so it's been over 30 years that they've been interpreting the statute. But you've seen a lot of activity since 2008 in particular, several declaratory rulings, several rulemaking proceedings. So now you have a body of law that's both the TCPA, the very thick CFR provisions, 47 CFR 64-1200, and then probably 500 to 600 pages of FCC rulings interpreting the statute over the last couple of dozen years. And that last piece, right, those interpretive rulings have really been the bedrock that the courts in the case law have looked to, and all of that is now out the window potentially. And it's really very, very fascinating to see how courts are now going to move forward interpreting the TCPA when a large body of the FCC's handiwork is now going to be out the window. But we have to pause because unlike most agencies, not all of the FCC's work is going to be out the window. The FCC and the Atomic Energy Commission have really, really very powerful powers. Why not? Granted to them under something called the Hobbs Act. And under the Hobbs Act, courts cannot mess with an FCC determination under the Communications Act. The TCPA falls within the Communications Act. So at least some things that the FCC does are still going to be protected from the courts quibbling through something called the Hobbs Act. The problem is that according to a different Supreme Court ruling, this time in something called PDR resources, not every FCC ruling is going to be entitled to Hobbs Act deference. Only final legislative rulings and not mere interpretive orders are going to be entitled to that heightened level of deference. Problem is, which ones of the TCPA rulings of the FCC fall into which bucket? And I'm going to tell you, the answer is not always clear because the commission works really hard and they've got some really smart lawyers there, but not everything they do fits so neatly into one bucket or the other. So everything that was solid is now kind of melting into air to a certain degree here in TCPA world. The one thing I think that is pretty solid, though, is the one-to-one rule. Unfortunately, the new modified express consent definition for express written consent in the lead gen context, that rule is set to go into effect in January of 2025. And I will tell you, I believe the APA NPRM rules were strictly followed. So I believe this will be a final legislative ruling. I believe it will be entitled to Hobbs Act deference and will become the law of the land. But so many other FCC determinations under the TCPA are now up for grabs. Are text messages calls? Can you still get express consent when you just receive a phone call, or sorry, when you receive a phone number from the consumer without any other, trappings of consent? There's a lot of rulings that have come out in interpretive settings that it's unclear to me that this is still going to be the law. So lots of really fun and exciting times here as we all try to adjust to this new Loper Bright decision. But again, the FCC and the TCPA world is only just one small piece of the ramifications of this very, very significant Supreme Court ruling.